So this next question is, what does the patent examination process look like? And they use kind of a funny word to talk about it. They'll call it patent prosecution. Your patent attorney is prosecuting your patent through the patent office, this administrative agency run by the federal government. Um, so during this process, you'll have filings. You'll file your patent. Provisional patents aren't examined, non-provisional patents are, right? So it could be a design patent, it could be a utility patent, it could be a planned patent. But anyway, you file your patent. The patent office will give you a filing date, which defines the priority by which you'll be judged against everybody else that's filed a patent. And then it'll sit in a queue waiting to be assigned to a particular examiner. It takes on average 18 months. There are ways to speed that up. You can fast track it, you can slow track it, but medium track is about 18 months to get assigned to an examiner. And then that examiner will perform a search to see what kind of prior art. And prior art is just a fancy word to say any sort of publication or disclosure that predates your filing. They're going to look at that filing date and they're going to search for things before that to see if you actually invented it or if it was invented by somebody else before you. So they'll perform a search. They'll also decide if there's maybe multiple inventions in there. You pay one filing fee to examine one idea. And if there's multiple ideas or inventions in there, they'll issue what's called a restriction requirement. And the restriction requirement simply says, look, pick the subset of this that I'll examine because it's one examination for one idea. So tell us which ones you want to go after. And then once you've got it down to the single idea, you'll go through rounds of argument. And with your filing fee, you've paid for 2 rounds of argument. The first round, called non-final office action. And then you have a final office action. And final doesn't mean final in the sense that your case goes away. It just means that you've kind of gotten your 2 rounds with the examiner. There are ways there are ways to have a judge look at it, an administrative law judge look at it, a panel of judges to decide if they agree or not with the examiner. That takes quite some time, around 18 months, to get that appeal to the judge. And when you get to the judge, you've exhausted your 2 rounds of argument with the examiner. Sometimes it goes 3 rounds or whatever, and the examiner typically is not a lawyer. They're just a trained engineer that knows how to examine cases. So sometimes getting to an ALJ, which is almost always always lawyers, and there's a panel of 3 of them, so you get a different set of eyes on that. But what typically happens, instead of going to appeal after the 2 rounds, you file what's called a request for continued examination, an RCE, and that buys you another 2 rounds. It costs about the same as the original filing fee. And you can file a RCE after RCE after RCE. And typically you're going to have 2 to 4 rounds of argument. I've seen 15 rounds of argument. In that particular case, no one had called up the examiner. You have the ability to do an interview, typically in the first office action. But you can do as many interviews as the examiner will allow. And in that case, no one had ever talked to the examiner, so it just kept churning and churning and churning, and there'd be rejection, an office action that has rejections in it. That's what comes from the patent office. Then you'll do a response, may have amendments in it. And as I looked at this case, it was just like ships crossing in the night. Nobody understood what the other person was arguing. So I had a quick interview, found some common ground, and we were able to get the patent allowed pretty quickly. So once you've negotiated with the examiner claim scope that overcomes the prior art and other rejections that they can throw at it, they'll do a notice of allowance. And then that just says, look, we're going to allow the case. There's some ability to kind of correct some formalities. And then once you pay the issue fee, typically six to 8 weeks later, you'll get your issued patent. And the overall process generally takes about 3 years, but of course you can speed it up or slow it down, and it depends greatly on how many rounds of argument you go through. Now, I should say that not all patents issue. The office average is around 70% of patents that are filed that are issue, but it varies widely based on the technology. There's some technologies that just have 5-10% chance of getting through, and there's others that have 90% chance of getting through. So once you get assigned an examiner, you can look at the statistics for that examiner to get an idea of where your application is being considered and what's likely to happen with it. So your patent ultimately issues or doesn't, and then it's enforceable from the day it issues. So you can file a lawsuit, the normal things that you can do with the patent. And then the patent office requires you to pay maintenance fees periodically after issuance. And they tend to get more and more expensive because they want you to think whether or not you still need this patent. And if you don't pay the maintenance fee and have it go away. And then you will have dedicated your idea to the public domain so that anybody could copy it, but maybe it's a technology that's no longer core to you. So I hope that answers the question. It's that's a high level treatment of what goes on, but there's a lot more to it, and there's a lot more twists and turns, and that's why your patent attorney, that's why you need to hire them to go through this process, even though you can do it yourself. It's really a difficult thing to do without the help of counsel. So at any rate, if you got something out of this video, hit the like button, subscribe if you haven't already to the channel, and we'll talk to you next time.